Thank you, Madam Chair, and welcome. Thank you to the panel. This is a complicated subject and one that I really wish the NCAA would have been able to figure out because, you know, there's certain things the federal government does well and certain things the federal government doesn't do well. This strikes me as something that we may not do well, and so I'm interested in hearing from you about what you think a proposal that should become law, if that's what we have to do, given the fact that states are now acting in the absence of NCAA action. And obviously, conferences don't follow state lines. We've got lots of multi-state conferences that could have different laws in place. So it seems to me that, you know, now we're in a position where we have to do something. But what we do is still a point of discussion. There are a couple of proposals I think you may be aware of that have been introduced by members of the Senate. I'm interested in your thoughts about either or both of those, and there may be perhaps others, but more than anything else, I just think that you're in a much better position to guide this process in terms of what a potential set of rules might look like than maybe we are. And, but I've been very interested in this discussion we were just having about employer-employee, and I think, Dr. Emmert, you mentioned that in your written statement at least, that you didn't think that you couldn't support anything that would essentially create an employer-employee relationship. And I would just ask you to sort of reiterate your view on why that's something that you prerequisite for legislation.
Yeah, thank you, Senator Thune. The issue of employment status versus being a traditional student athlete, as that's been defined historically, is really at the core of what college sports is all about. If student athletes are classified as employees of their university, their college or university, it is, as Senator Schatz pointed out, it does change very fundamentally the nature of that relationship. It moves student athletes out from underneath the guise of education law, for example, to employment law. I believe that's what the good senator was alluding to, and for one, that means Title IX is no longer relevant to college athletics because that's education law, not employment law. It changes the relationship between Coach Few and as a student athlete says coach-student to employer-employee. It changes everything about what college sports really is and why we have created college sports 120 some years ago. So everybody in higher education sees that question as one of the core issues to defining college sports versus professional athletics.
So and just again, by way of, I come from a state, we don't have, we have two mid-major universities and a number of Division II schools in South Dakota. And you've touched on this a little bit, I think some of you have in responses to questions already. But how do you see this playing for you know, a University of South Dakota or a South Dakota State University where you've got a mid-major program, the transfer portal already, which I think is very much a benefit to athletes, makes it harder, I think, for a lot of those types of schools to keep athletes, retain athletes once they get them there. But how will this affect recruiting athletes, and does it put those types of universities at a competitive disadvantage relative to a Power 5 conference?
Well, I think first of all, Coach Few could answer part of that question very, very, very well. I think especially with the patchwork that we're going to see starting July 1, those schools that are in states that allow name, image, and likeness opportunities are going to have an enormous advantage in the transfer portal as well, because student athletes will indeed be looking for opportunities to transfer to schools where they can monetize their name, image, and likeness. It's one of the reasons we need, of course, the nationalized rule. The second component is we need those set of guardrails that we've been describing so that students can monetize their name, image, and likeness, but it's not being used as a recruiting inducement. Absent some guardrails, coaches and others will in the recruitment process be including in their recruitment pitch a specific opportunity for a specific contract or a specific endorsement deal at a specific place. That's precisely what we want to avoid. And the legislation that's been discussed here in this chamber has always included those kind of guardrails.
Coach, any comments on how it will impact?
Thanks, Senator. Absolutely. I mean, the impact would be enormous. And if you were from a state like South Dakota or Washington, you would be put at a huge competitive disadvantage and one that would be very difficult to make up, both when the student athletes are coming out of high school, but also, you know, as they have the opportunity to transfer. And, you know, speaking to Dr. Emmert's point, you know, having some sort of parameters in line so we can keep some sort of semblance of competitive equity in recruiting, you know, where we're talking about, you know, each of us being able to give a similar experience to these players, and it not turning into basically a bidding war where it's just monetarily based.
And that's what I'm afraid what could happen and what we obviously have to avoid. And Madam Chair, again, I would say I think it would be a benefit to all of us to hear specifically from people who I consider to be experts who deal with this every day, what they think this might look like if we are to legislate on this. And it sounds like from a time standpoint, we don't have a lot of time. We need to come up with something in fairly short order. So I hope we can get working on that right away.
Thank you. Thank you.